May I please, Your Lordship? Lordship, I'd like to mention hearing item number 20 on behalf of Victor Zimo, government advocate. And due to some personal difficulties.
Item
20,
20,
Mr. Lordship.
the only hearing item today.
Yes, Your Lordship.
Yeah,
Due to some
Yes.
personal difficulties, we pray that maybe listed after 1 week, Your Lordship.
you're mentioning on behalf of
With V. Zimomi.
Simomi.
Yes, government advocate.
It is okay with you? Learned Government Council, M. Longcomer has mentioned on behalf of Mr. V. Zimomi, Government Council, who's appearing on behalf of the state respondents, to adjourn the matter for 1 week. The prayer is not objected by the petitioner. List the matter after 1 week.
Your Lordship, I'll also like to mention item 2 and 3 on behalf of V. Zimomi. We pray for,
3 admission.
yes, Your Lordship.
Okay.
We pray for 2 weeks to file an affidavit in opposition.
Yes. Item 2 and 3 admission. Prayers made on behalf of Mr. V. Jimomi, government advocate, to list the matter after 2 weeks.
Yes, Your Lordship.
In order to enable the government to file the counter affidavit. Prayers allowed. List the matter after 2 weeks. Learned Council for petitioner. Lucino is present. Yes. After 2 weeks. Okay.
Obliged, Your Lordship.
With Mr. Lordship. Lordship, I'd like to mention item number 5 to 19. Analogous method.
19 analogous matters.
I'm for the state here.
Yes.
I will allot 2 weeks time, Lordship. To file state counter.
To file counter.
Correct, Lordship.
This is 2021 matter. Or some are 24. Any objection?
The urgency here is still, I'm challenging the implementation order. So the next negotiated count will be filed.
I have received otherwise comments, instructions, but I'm seeking some clarification. That is why
How much time do you need? 2 weeks.
2 weeks time.
Item 5
To
to
19.
19. Okay. Kim Chen, Lieutenant Government Advocate, has prayed for 2 weeks' time to file his counter affidavit, as he has received instructions. So, prayers allowed. Learned Counsel for the petitioner states that there is some urgency as he is challenging the termination order of the petitioners. Accordingly, the government advocate is directed to make all endeavors to file the same within the next 2 weeks. At least after 2 weeks. Yes.
Publish.
Your Lordship, I beg to mention item number 4 on behalf of the senior and Longcomer.
On behalf of N. Longcomer. Yes.
Your Lordship, in this case, I might put a respondent number 11. That Nakaling Information Commission.
Okay.
This case was filed in the year 2022. And Lordship, the then Chief Information Commissioner, your husband, Lordship. Well, he was the Chief Information Commissioner, he was employed as a party. So he may be listed before, not before, Lordship.
Okay. This matter may be listed before another bench without me.
Yes,
So after maybe 2 weeks. After 2 weeks. Yes.
For motion, item number 1.
My Your Lordship, Your Lordship, this contempt petition is filed for non-compliance of this honorable court order dated 4/12/2023. The respondents were directed to regularize the service of the applicant petitioner within a period of 4 months. Since the government has already initiated the process for regularization of the service of the applicant petitioner. Till date, Your Lordship, there is no compliance from the respondent, hence this contempt petition, Your Lordship.
Where is the operative portion? The judgment is at page
Page
7,
nine,
page 9.
9, yes, Your Lordship. Last
Yes.
paragraph, may I read?
Yes.
On considering the fact that there is nothing left to adjudicate in this case, as the state government has already initiated the process for regularizing the service of the petition, this court is of the view that the state respondents should complete the process of regularizing the service of the petition within a period of 4 months from today.
This was dated
Dated
4/12.
4/12/2023.
Third learned counsel for the petitioner, MS
Atsala Kips.
Priscilla Gibbs, appearing for the petitioners in this application under section 11 and 12 of the Contempt of Courts Act 1971. Read with Article 215 of the Constitution of India. So it is submitted that this court, by its order dated 4/12/2023 in WPC 203/2021, had directed the state respondents to regularize the service of the petitioner within a period of 4 months from the date of the order. Stop. It is the contention of the petitioner that the state respondents have not complied with this direction till date, and hence the present application. Stop. Issue notice to the respondents 1, 2, and 3, returnable within 4 weeks. The petitioner shall take steps for service by registered post with AD within 3 days.
5 days may be
Within
granted.
5 days. It's the matter of the 4 weeks.
Obliged, my lord.
For motion from the supplementary cost list, item number 21.
What happened?
May please, Your Lordship. My lord, the petitioner is challenging the complaint dated 17 March 25 submitted to the DGP Nagaland by the chairperson of Women Commission, whereby it is alleged that the petitioner has committed sexual and mental harassment at workplace in the office. So, my lord, I'll just, the short facts are very short. Coming to paragraph 2, my lord, so that lordship will be in a better position to know the facts of the case. Paragraph 2, my lord. May I read it, my lord? That it is stated that while your humble petitioner was working as the joint secretary in the office of the Investment Development Authority of Nagaland, within bracket, IDEN, under Planning Department, Government of Nagaland, the chairperson of NSWC issued a notice dated 4/3/25 to the chairperson, IDEN, against the petitioner, alleging workplace sexual harassment. It is also mentioned in the said notice that the chairperson, NSCW, in exercise of the power under section 5 and 6 of the Nagaland Women Commission Act 2006, directed the chairman, IDEN, to furnish all the details of the female employees under the establishments of IDEN. However, in the notice, it is not referred to any specific complaint or incident. May I take lordship to NHA, page 20.
NHA.
Page, NHA, page 20. It is called notice. Notice to the chairman, Investment Development Authority of Nagaland, Kohima. This is dated 4 March 2025. notice, whereas it has come to the notice of the commission from reliable source on 25/2/25 of sexual harassment under your establishment. Accordingly, the NSCW took cognizance of the matter and met the chairman of IDEN on 27/2/25 in the office of IDEN. That upon hearing, the chairman of IDEN apprised the commission of the sequence of the meeting where the victim had addressed their grievances in regard to sexual harassment at workplace by the alleged accused, Mr. Rainey Wilfred IAS, Joint Secretary IDEN. Therefore, taking into consideration of the nature and gravity of the offense, in section 5 and 6 of the Nagaland Women Commission Act 2006, you are hereby directed to furnish the name, designation, and contact number of all women employees under your establishment item. Take note that the list of details be furnished in a sealed package to the commission office. Now, take notice that your esteemed office is required to furnish the necessary information as sought by 5/3/25 in the said given address without fail, Nagaland State Commission for Women, NBCC Complex, first floor, Middle Bayaver, email so and so, given under my hand and the seal of the commission, this the 4th day of March 24, by W. Ponyak, Chairperson, NSW. This is the notice to the chairman of IDEN. Now I'm coming to paragraph 3, my lord, page 5. That on 5/3/25, someone notices were issued to the female employees to appear before the NSCW members on 7/3/25 at 10:30 a.m. at the chair commission office. As per the summon letter, the NSCW has the power to record a statement of the alleged female work employees under section 6 of the Nagaland Women Commission Act 2006. Madam, Your Honor, they have split mentioned that they have the power under section 6 of Women Commission 2006, which is not. I'll explain later on about the law.
You have the act with you.
I have. I'm going to provide to the lordship. Paragraph 4, because section 6 doesn't provide any criminal power, civil in nature. I'll show that, man. Paragraph 4, that on 17/3/2025, the chairperson NSCW has submitted a written complaint against Mr. Rainey Wilfred IAS, Joint Secretary, IDEN, Kohima, addressed to the DGP Nagaland, alleging that sexual and mental harassment was committed at workplace. At workplace is very important because there is a special law to deal with this.
Posh Act.
Yes, 13, which is enforceable all over India, including Nagaland. Such complaint was submitted after recording the statements of the alleged aggrieved female employees by the NSCW. In the complaint, the NSCW claimed that it has been empowered under section 5 and 6 of the Nagaland Women Commission Act 2006 to take cognizance of the offense and record the statements. The DGP Nagaland is requested to register a criminal case under appropriate sections of BNS 2003. May I take lordship to NHSC, page 22. Page 22, Milo. This is the formal AFR, a complaint. May I read it, my lord? This is dated 17 March 25. To the Director General Police, PHQ, Nagaland, Kohima, subject complaint against Rainey Wilfred, IAS, Joint Secretary, IDEN, Kohima, Nagaland. Sir, the Nagaland State Commission for Women received a verbal intimation by way of complaint from the chairman of IDEN, namely Sri Abu Mehta, on 23/2/25, 27/2/25, with regard to sexual and mental harassment towards some of the female employees of IDEN office by Sri Rainey Wilfred IAS, Joint Secretary, IDEN, Kohima. Accordingly, the NSCW took cognizance as empowered under section 5 and 6 of the Nagaland Women Commission Act 2006, and necessary steps were initiated for recording the detailed report of the said offenses, thereby recorded the statement of the victims, within bracket, details are kept sealed and confidentiality purpose. It may be mentioned that the statements were recorded as per the named list provided by the Undersecretary IDEN on 5/3/25. The offenses committed, the commission has already come to a finding deal that he has already committed the offense by the perpetrator are extremely alarming, and such a gruesome act by a high-ranking government official upon its inferior officials slash staffs is highly uncalled for. The act per se speaks a volume of distressing act meted out against the victims by the perpetrator. Therefore, in view of the above and considering the facts and circumstances and the nature of the offences, the NSCW hereby put forth this complaint to register a case under appropriate sections of BNS and protection of women from workplace and any such befitting laws deemed proper. Next page, my lord. Page 23, continuation. In furtherance, the state law enforcement agency is requested to take necessary steps and ensure protection of women employees, victims, more specifically as per section 72 of BNS. This is for your information and necessary action on top priority signed by chairperson, Madam Konyak. Now coming back to paragraph 5, page 7, my lord. Facts are about to be finished. Paragraph 5. That thereafter, K. Lucy Yome, NPS, Deputy Superintendent of Police Intelligence, PHQ Kohima, was appointed inquiry officer to conduct preliminary inquiry into the allegations. The inquiry officer has submitted her inquiry report on 1/4/25 to the Superintendent of Police within Brigade Crime, Kohima, recommending for thorough investigation. In her recommendations, particularly recommendation number 1, the inquiry officer has recommended as follows, quote, 1. The testimonies provided by the victim clearly meet the criteria for sexual harassment as defined under the Post Act 2013. Inquiry has already done, preliminary inquiry was done, and it is proved that it is a clear case of Post Act 2013. This includes whether directly or by implication, sexual advances and requests for sexual favors, sexually colored remarks, and unwelcome physical, verbal, and non-verbal conduct of sexual nature, unquote. Page 24, madam. Just to show the relevant paragraph only. Start from page 24. This is the preliminary inquiry report submitted SP by the inquiry official, but relevant price page 25. Page 25. Recommendation number 1. May I read, my lord?
Yes.
Based on the following findings of the preliminary inquiry, a more thorough investigation is recommended to ascertain the facts of the case. 1. The testimonies provided by the victims clearly meet the criteria for sexual harassment as defined under the Post Act 2013. So therefore, it will not come under BNS. This includes whether directly or by implication, sexual advances and requests for sexual favor, sexually colored remarks, and unwelcome physical, verbal, and non-verbal conduct of sexual. That much I'm just reading. So meaning thereby the police themselves have come to know the existence of Post Act 2013, and therefore this matter should be referred to the internal ICC, Internal Complaint Committee. But in this case, they have not done that. Coming back to page 7, paragraph 6. Well, may I read it?
Yes.
That based on the complaint, the State Crime Police Force, paragraph 6, that based on the complaint, State Commission, Women Commission complaint, the State Crime Police Station, within for short, for brevity SCP, case number 1/2005 was registered on 2/4/25 against the petitioner under section 74, 75, 2, 79 of BNS 2023 for further investigation. The classification of offenses under BNS 2023 given below will clearly show that none of the penal sections slapped against the petitioner will be applicable in the case of alleged sexual harassment at workplace. My lord will see I have reproduced for lordship's perusal. Section 74, assault or use of criminal force to women with intent to outrage her modesty, not at workplace. Section 75(2), sexual harassment and punishment for sexual offenses specified under clause 1 or clause 2 or clause 3 of the subsection 1. This is not at workplace, because all the workplaces are to be governed by Post Act 2013. That's why I'm trying to show. 79, uttering any word or making any gesture intended to insult, the modesty of a women not at workplace. All this will, if this offense was committed other than workplace, yes, that is my sum. I'm coming to that. Now, my lord, paragraph 7, that as mandated under section 4 of the Act 2013, Post Act 2013, the governor of Nagaland is pleased to constitute the complaint. Can I continue?
Yeah, please continue.
That as mandated under section 4 of the Act 2013, the governor of Nagaland is pleased to constitute the complaint committee for the state level committee consisting of 6 members, which is still in force. Such state level internal complaint committee is extended to all the departments. The notification number so that 29/8/2022 was issued in the name of Chief Secretary to the government of Nagaland. Also, even the item which is under planning department has its own ICC duly constituted on 3/3/2025. May I take lordship to the constitution of the ICC, page 29.
29.
Page 29. State level committee was constituted to look into all these kind of sexual harassment at workplace, in terms of Post Act 2013. May I read it? This is issued in the name of governor. Notification dated 29 August 2022. In supersession of this department's notification of even number dated 19/11/26. 16. The governor of Nagaland is pleased to constitute the complaint committee for the state level committee as per the provisions of sexual harassment of women at workplace within bracket Prevention, Prohibition, and Redressal Act 2013, consisting of the following for redress of complaint relating to sexual harassment of women employees of the state government at their workplaces. So, Your Honor, these are the members, 6 members. Terms and conditions are very important. Terms and conditions of the complaint committee. 1, the committee shall receive complaint from any woman who is a victim of sexual harassment at her workplace and cause any inquiry into the complaint and suggest measure to redress the complaint. So, my lord, if there's any complaint, that I have to submit complaint to the ICC, Internal Complaint Committee, to redress the grievances. Then, condition 2, I skip, this is not very relevant. I come to condition 3. Complaint committee will be deemed to be an inquiry authority for the purpose of central/state civil services conduct rules, and the report of the complaint committee shall be deemed to be an inquiry report under the rules. Therefore, thereafter, the disciplinary authority will act on the report in accordance with the rules. Now, if there is any sexual harassment allegation at workplace, complaint will be filed before the ICC. After that, the inquiry report conducted by ICC will be taken as report. Then it will be referred to disciplinary authority, means employer department.
See,
So-
under the Posh Act,
Yes.
it is something like a disciplinary proceeding.
Yes, it
Okay,
is there.
but just as a criminal proceeding can proceed simultaneously with criminal proceeding as well as disciplinary, so same thing here also. This proceeding can continue and nothing stops a criminal proceeding. Okay. Yeah, anyway,
I'll come to
yeah.
I'll come to the Post Act 2039 and I'll satisfy lordship. Then coming to the next page, page 13. This is the committee considered under item 3rd March 2025. In compliance with section 4 of the sexual harassment of women at workplace, Act 2013, and in order to ensure a free, easy, and transparent grievance redressal mechanism within the office functioning, the Internal Complaints Committee, ICC, of the Investment and Development Authority of Nagaland is hereby constituted with the following members. So 5 members. This committee shall function to address and resolve all the office-related grievances, including cases related to sexual harassment as mandated by the Post Act 2013. The committee is entrusted to handle all complaints with utmost confidentiality, fairness, and impartiality, ensuring a safe and equitable workplace environment. This order is issued with the approval of Chairman Iden and shall come into force with immediate effect. Signed by Soisu. Now, my lord, coming back to page 9, paragraph 8. Page page 9, paragraph 8.
Mm.
That many of the female employees of Iden office have given clarification regarding the sexual harassment of women at workplace and submitted to the chairman / grievance redressal officer, Iden office, clarifying that they have neither experienced nor witnessed any form of harassment in the workplace from the joint secretary Iden or other senior official of Iden, and further clarify that they have neither submitted any complaint nor given consent to file any complaint or letter against Vishnu as alleged. Some of the descriptions are annexed for ready reference. Page, just because when the chairperson of NSW submitted a complaint, no name has been mentioned and no specific reason. So now, these are the people who said, we have never attended any meeting, I have never lodged complaint. This is what I have given clarification. Page 31.
Mm.
Dated 4/4/25.
Mm.
To the grievance redressal officer, investment and development authority.
Don't read the whole thing, just show me the para where they have
Yes.
stated that
Uh,
they
your-
did not
My
attend.
lord, then come to
Last para.
second last para.
Mm.
It was also informed during the meeting that NSCW has filed a formal suo motu complaint to the police based on the statement that were recorded from the women employees of Iden, where they were summoned for counseling on 6 March 25. We were also informed that we will now be called for interrogation by police as per investigating procedures. Even though women employees are made party to this complaint, we are still not provided with a copy of complaint filed on our behalf, nor on our behalf, that is important, nor provided details of how the statements are recorded for submission to government and police. The alleged affected people are in the dark. What is happening? The complaint of the commission is lacking transparency while being filed on suo motu on behalf of the undersigned as well. I am concerned that this complaint lodged on behalf of me as well as in any way affecting my dignity as a working woman and violating my human rights. The next page, my lord. This is addressed to chairman. Earlier was grievance committee. This is to chairman. Relevant paragraph is second last paragraph.
Mm.
Following the summon, I was made aware of false rumors suggesting that I was withholding information and that I had been molested, both of which are entirely untrue. Entirely untrue. Such baseless allegations have been distressing and misleading. I would also like to reiterate that my engagement at Iden has been through an interview with Learning Links Foundation. Subsequently, consider for engagement in Iden post my contract period with LLF. This is the clarification that they were never, the allegations are untrue. Then next, the 33 by Dr. Nchumbeni, addressed to Chairman, Investment and Development Authority of Iden. This is Iden.
This page 31 and 32 is same person.
Same person, but addressed to different authority. That is the point. Same person, but to different authorities. Now 33 is another person. Relevant paragraph, second paragraph, my lord. It has come to my attention that allegations are being circulated insinuating that the appointment of female employees, including myself, were made based on personal favors from Sri Reni Welfare, Joint Secretary Iden. I categorically deny this insinuation and we wish to place on record that there has been no instance of sexual harassment by Sri Reni Wilfred, Joint Secretary to the Government of Nagaland, nor was any appointment influenced by any personal consideration. So this is by another female employee in Iden. Then this is by same any, but this is different issue because they all have been their name have been shown that they have attended a meeting, all by chairman. So therefore she is saying that I have never attended such meeting. Attendance. To clarify this attendance. The second para is relevant only. Nah? Second para. So that is the only clarify that she was not attended that much. Then I'll skip to reading. Then paragraph page 35. another person, female person. This is to Chairman Aiden. The relevant paragraph is paragraph 2. Paragraph 2. It has come to my knowledge that my name has been included among those allegedly subjected to sexual harassment by Sri Reni Welfare, Joint Secretary to the Government of Nagaland. I would like to categorically state that I have never experienced any such incident involving Sri Reni Welfare. The inclusion of my name in this matter is false, unfounded, and deeply distressing. This is the relevant paragraph. Then page 37, another person, another government, women, a female employee. Page 37, last page. To Aiden, Chairman Aiden. The only first part I read, my honor, my lord. I, Mrs. So-and-so, have been working at Aiden as my peon since 2022. I was appointed by Sri Alamtemshi Jamir, the then CEO of Aiden. I would like to kindly say that I have never faced any bad or inappropriate behavior from the Joint Secretary, Sri Reni Welfare IS. That much. Then last paragraph of the same letter. I kindly request that my name be removed from the list of complainants and from the given to the NSCW. I am not involved in this matter, and it is causing me a lot of stress and worry. I did not choose to be part of this situation. So this is what he has stated. Now coming back to paragraph, petition paragraph 9, page 10, my lord. Now, that the allegation against sexual harassment of women at workplace, like in the present case, will come under the special law called the Sexual Harassment of Women at Workplace Post Act 2013, and not under the general law like IPC DNS 2013. The relevant provisions of Post Act 2013 to consider for the present case is reproduced below. This is how the committee is constituted.
Yes.
Yes, I don't need to read my lord.
Yeah.
Now this is how, because ICC has
Yes,
under
that we
section
know.
4. Then 9 is relevant. Just to read out 9. Page 12. How complaint has to be filed by any aggrieved person. Complaint of sexual harassment. Subsection 1. Any aggrieved women may make in writing a complaint of sexual harassment at workplace to the internal committee, if so constituted. In our case, it is constituted, or the local committee in case it is not so constituted within a period of 3 months from the date of incident, and in case of series of incidents within a period of 3 months from the date of the last incident, provided that where such complaint cannot be made in writing, the presiding official or any member of the internal committee or the chairman or any member of the local committee, as the case may be, shall render all reasonable assistance to the women for making the complaint in writing. Provided further that the internal committee or, as the case may be, local committee may, for the reasons to be recorded in writing, extend the time limit not exceeding 3 months if it is satisfied that the circumstances were such which prevented women from filing a complaint within the same period. 2. This is relevant. Subsection 2. Where the aggrieved person is unable to make a complaint on account of her physical or mental incapacity, or death or otherwise, her legal heir or such other person as may be president may make a complaint under this section. So in this case, in the present case, none of the aggrieved person has come forward before the ICC. No one has come forward. 11, section 11, this is relevant for consideration. Section 11, once ICC received the complaint, how to consider? Inquiry into complaint. Subsection 1, subject to the provisions of section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make an inquiry into the complaint in accordance with the provisions of service rules applicable to the respondent, and where no such rule exists, in such manner as may be prescribed, or in case of domestic worker, the local committee shall, if prima facie case exists, forward a complaint to the police within a period of 7 days for registering the case under section 509, 509 in the present 79 under BNS of the Indian Penal Code and any other relevant provisions of the state code where applicable. So here, Your Honor, it's very clear, the law is clear. If there is service rule for the respondent, means alleged accused, then after receiving the complaint, it will be considered as part of the service rule. If service rule not existed, then after inquiry, it will be forwarded to police. Provided that where the aggrieved women inform the internal committee or the local committee, as the case may be, that any term or condition of the settlement arrived at under subsection 2 of section 10 has not been complied with by the respondent. The internal committee or the local committee shall proceed to make an inquiry into the complaint, or as the case may be, forward complaint to the police. Now, the proviso is, suppose after section 10 talk about conciliation. If there is complaint, then respondent and complainant has to come together for conciliation. And after conciliation process is over, if the respondent refuses to accept, then it will be forwarded to police. In the present case, this is not the case. 2, subsection 2, notwithstanding, provided further that where both the parties are employees, the parties shall, where both of us were employees, Rainy and the alleged people are employees, the parties shall, during the course of inquiry, be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representations against finding before the committee. In the present case, no notice was given to me, no hearing was given to me, so there is a clear violation of the principle of natural justice. Fundamental principle of natural justice is violated. 2, notwithstanding anything contained in section 509 of the Indian Penal Code, the court may, when the respondent is convicted of the offense, order payment of such sums as it may consider appropriate to the aggrieved women by the respondent, having regard to the provisions of section 15. 3, for the purpose of making an inquiry under subsection 1, the internal committee or local committee, as the case may be, shall have the same power as are vested in a civil code of the Civil Procedure 1908 when trying a suit in respect of the following matters, namely, summoning and enforcing the attendance of any person and summoning him on oath. B, requiring the discovery and production of the document, and C, any other matter which may be prescribed. The inquiry under subsection 1 shall be completed within a period of 90 days. So the summoning recorded statement will be under CPC, not under CRPC. In the present case, it has been followed CRPC. 10, that in the instant case, NSCW does not have the power to take over the functions of Sexual Harassment Committee called the Internal Complaints Committee, ICC, suo motu under Post Act 2013. If there is any complaint of sexual harassment at workplace filed by any aggrieved women employee before NSCW or any other authority, such complaint has to be transferred to ICC constituted under sections 4 of the Post Act 2013 for consideration. 11, that in the present case, NSCW has usurped the powers of ICC and bypassed due process of law provided under the Post Act 2013, inasmuch as the NSCW has recorded a statement of the alleged victim and thereafter submitted a written complaint to DGP Nagaland for registering a case. Thus, the action of NSCW is ultra virus. I'm alleging this is ultra virus because that exceeded the power. This is not within their jurisdiction. 12, that no aggrieved women or women employee of the Iron Office has filed any written complaint of sexual harassment at workplace to the Internal Complaint Committee as provided under section 9 of the Act. That the assumption of the 13, that the assumption of jurisdiction by the NSCW under section 6 of the Nagaland Women Commission Act 2006 prima facie appears to be wrong and lacking jurisdiction in as much as no criminal jurisdiction has been vested with the NSCW but vested with civil jurisdiction. 14. That the NSCW has exceeded its jurisdiction in acting like the ICC or an independent investigating agency, even to the extent of recording findings of guilt conclusively mentioned at paragraph 3 of the complaint letter dated 17/3/2025. 15. That the NSCW should not have and could not have summoned the alleged aggrieved women employees working under the establishment of Iden office and recorded their statements. There is always the possibility of a biased and predetermined approach on the part of NSCW. 16. That the object and reason for passing the legislation, namely the Nagaland Women Commission Act 2006, is not to empower it with roving inquiry and even to the extent of summoning the alleged victims and launching criminal FIR on behalf of the alleged victims with a conclusive finding of guilt against the petitioner, prejudicially affecting his defense. Paragraph 17, my lord, page 16. That the alleged aggrieved women employees of Iden office, being all adults, are entitled to lodge their complaint to the internal complaint committee as required under section 9 of the Act 2013 without any intervention of the third party NSCW, whose conduct is also unbecoming of a statutory body. 18. That the manner and method in which the commission has conducted itself speaks volumes of its biased approach against the petitioner, that too without hearing him in the matter, and for that matter, the petitioner versions of the story. Therefore, it is a clear case of violations of the principle of natural justice. 19. That the police also ought not to have relied upon the complaint that is 17/3/25 of the NSCW towards taking cognizance of the matter, as the allegations of sexual harassment of women at workplace come under the purview of the special law called the Sexual Harassment of Women at Workplace Act 2013, enacted by the Parliament, and therefore the general law like IPC BNS 2023 will have its application only after the process is completed under the Post Act 2013. 20, paragraph 20, that the whole approach of NSCW in filing the complaint smacks mala fide exercise of power not vested on it, requiring immediate intervention of the whole Honorable High Court in the interest of justice. 21, page 17. That your humble petitioner respectfully pray that this Honorable Court may be gracious enough to stay the operations of the impugned complaint that is 17/3/2025 and FR being SCPS number 1 of 2025, dated 2/4/25, registered under section 74/75(2/79) BNS 2023, pending disposal of the present case. So these are the submission. Now, my lord, if lordship wanted to see the act, Post Act 13.
No, Post Act is
Okay.
okay.
Then Women Commission.
I've been going to the ATA for lectures on Post Act. So don't, it's
Then
okay, but I want to see the
Women-
Women Commission.
Women Commission. Women Commission Act 2006. My lord, the relevant paragraph, section 5 and section 6, my lord. Section 5 and 6 is very clear that they don't have any criminal jurisdiction.
No, that is clear.
Yes. Section 5,
It's section 5 functions. of
section 5 and section 6.
commission. They have inquiry power.
Yes, no, that was civil in nature,
Civil in
as
nature.
per CPC,
To
not as per
summon-
CRPC.
No, that is not disputed. See,
Yes,
your entire petition
yes,
is only about the illegality of the proceedings of the ICC
yes.
and then illegality of the proceedings of the State Women Commission.
Yeah, take
But,
of
but your petition is a petition under 528 CRPC. Okay. And there's nothing here against the FIR. When there is a cognizable offense and there's a prima facie case, what stops the police from registering an FIR?
My lord, as I have read out.
Forget about the ICC.
Yes.
That is a different issue. That is like a departmental proceeding. That let it continue. Simultaneously let it continue. But in a criminal proceeding, you have to show the court why the court should quash the FIR.
There, I'll show.
We have not stated anything
I'll
about that.
show. I'll show because right now,
But at this stage, we'll issue notice.
right now, I'm just showing, I'll just show one, two judgment on that. The jurisdictions of the National Women Commission, which was decided by the court that no, National Women Commission, your power is only to recommend. And you have to see the larger aspect of the policy matters and just to recommend. You cannot register any, you cannot file any criminal complaint. Now, your honors, your lordship query, if I mean, yeah, I understand that lordship has vast experience about that. If we go by the Post Act 2007, the 13, section 27, I'll just to refresh our memory. Section 27, cognizance of offense by courts. No court shall take cognizance of any offense punishable under this act or any rules made thereunder, save on a complaint made by the aggrieved women or any person authorized by the internal committee or local committee in this behalf. Then no court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try and offer any offense punishable under this act. 3. Every offense under this act shall be non-cognizable. So therefore, when there is any allegations of sexual harassment at workplace.
But when there are ingredients of 78, 75 to BNS, then?
That is what I'm saying. It should have come under Post Act. Therefore, the registration of FIR itself is wrong. That's why I'm challenging that. Under 226.
Okay, we'll examine.
Yes,
But
yes.
then we'll
Now-
just issue notice. Yes.
I'll just show whether
I know that you want an interim order.
Yeah.
Anyway,
Now-
just.
yes. Now, just for the interest of justice, my lord, I have a judgment passed by the Delhi High Court. No, before that, citation is submitted. My lord, this Post Act has been enacted based on the Supreme Court judgment passed in Vishaka. So in the Vishaka, lordship knows very well. In Vishaka case, Supreme Court held that the general law like penal law, IPC is not enough to deal with the allegations of sexual harassment at workplace. So for guideline has been given. So this is reported in 1997. Now after that, lordship is aware of that. So after that, what is the judgment? Next.
You just point out the relevant part.
Yes. I'll take lordship to Varma case. Citation institution. My lord, I'll just come to, this is Varma case.
Burma versus National Commission.
Yes, National Commission. Whether they have the power
This
to,
one.
yeah, whether they have the power to file FIR or not, or what is the jurisdiction here in Burma, lengthy. I'll take lordship to paragraph 42 only, paragraph just 42. 42. Whether they have the jurisdiction to, like in the present case, whether they have the power to file FIR.
Paragraph 42.
Yes, paragraph 42. Mary,
Yes.
paragraph 42. As a result of the above discussion, it is held that the commission could at best have investigated into the matter upon receipt of the complaint from the teachers with the aim of finding out if the management of the school had taken or was contemplating taking any step towards following the Vishaka guidelines for determining whether any sexual harassment had taken place. So that aspect has to be inquired into. It could certainly have commented if no response was taken and suggested that, or adequate measures to follow the guideline had to be taken. However, it could not have inquired into the matter in a manner in which the committee required to be set up under Vishaka could have, saying that the commission could have performed that role would be permitting it a function that had to be discharged primarily by the employer and setting up the Vishaka mandate mechanism. That is clearly beyond the domain of the commission's jurisdiction. Another way of looking at the matter is that wherever an employer does not act or acts contrary to Vishaka, automatically the commission would be empowered to examine and decide on the nature of the complaints, within bracket non-complaint, with a law jurisdiction that is clearly that of the courts of law. The power to so decide is essentially a judicial one and cannot, unless the contrary statute so and so had so provided, be performed by the commission. Here, the commission not only look into the materials, but also examine witnesses, just like our case, to decide whether the allegations were well-founded or not. Such an exercise cannot be termed as a fact-finding one, aimed at investigating whether the Vishaka guidelines were followed. It clearly impinged on the merits and veracity of the allegation, and decided the complaints that the final recommendation suggested remedial action by appropriate authorities detract from the objective fact that the report of the commission reflects and decides the truth and veracity of the allegation. The finding in the report on the merit were, in the opinion of the court, therefore clearly beyond the commission's jurisdiction. This is what I am just pressing in this case, because commission has no jurisdiction to inquire into all this and file a FIR. Yes, this is the judgment. Then, my lord, I'll show another judgment, just 2 paragraphs only. This is you have given the copy. This is also one of the latest judgments, Delhi High Court. The judgment passed on 25th January 2023. Here also, same like me, they also have filed under 226, read with 482. 482 earlier. Now, here the allegations, same allegations of sexual harassment workplace. I'll take lordship to paragraph 12.2, page 12, page 28, my lord. Same case like us. 28, page 28, paragraph 12.2.
Supreme Court.
The Supreme Court, instead of Haryana versus so-and-so, Supra so-and-so, has laid down guidelines for the high courts under which inherent powers also under section 482 of the court can be exercised, which are as under 8.1. 8.1, I'll not read my law. I'll just give. I'll come to 8.1a. Where the allegation made in the first information report of the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. In the present case, my lord, the complaint filed by the chairperson, no name has been, no date, no specific date, no specific plan has been indicated, just general complaint. B, where the allegation in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense justifying in an investigation by police official under section so-and-so of the code, except under an order of a magistrate within the purview of section so-and-so of so-and-so. Then come down to D, where the allegations in FIR do not constitute a cognizable offense, but constitute only a non-cognizable offense. No investigation is permitted by a police official without an order of a magistrate to contemplate under section so-and-so court. Now in our case, sexual harassment at workplaces under post, so there is non-cognizable. E, where the allegation made in the FIR or the complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. F, where there is an express legal bar engrafted in any of the provisions of the court or concerned act under which the criminal proceeding is instituted, to the institution and continuance of the proceeding, and or where there is a specific provision in the code or the concerned act providing efficacious redress for the grievance of the aggrieved party. Now, in our case, there is a special law apart from CRPC, where the aggrieved family, aggrieved member can approach. So in that case, it is barred for the police as well as the complaint to file FIR under CRPC. That's one. Now, this is the, so now coming to paragraph 14, the result, the same case, paragraph 14, page 31. If the consequential proceeding arising out of FIR bearing number so and so are allowed to be continued, it will be misuse of power and exercise in futility. In view of our discussion, the present petition are allowed and FIR number so and so under so and sections are same with us is quashed along with the consequential proceedings, including judicial proceeding quashed so and so. So this was filed as writ petition criminal like us. What is this? Yeah. My lord, I'll just show another case. This is Narendra Kumar, where there is no specific allegation of against the accused. Paragraph 17. Paragraph 17, 18, and short one. Paragraph 17, my lord.
Please read.
17. Thus, it is evident that though according to non-application number 2, the applicant was harassing and stalking her since August 2017 till she did not make any complaint against him to the higher official or the ICC when she claimed herself as an activist and representative of the staff. She has not assigned any reason for belatedly lodging the first information report. A bare perusal of the allegation in the complaint prima facie do not disclose that non-applicant number 2 has made any specific allegation against the applicant of harassing her or stalking her. So in the present case, no specific allegation. Where, how, when, nothing. Now, my lord, I'll come to paragraph 18. Para 18.
Yes.
To sum up, para 18, to sum up, it appears that the allegations made against the applicant are general and vague, even in the present case. Complaints made of a chairman is just general and vague, which do not prima facie constitute any offenses as alleged by non-applicant number 2. Therefore, considering the facts of the case, findings recorded by the committee headed by the assistant manager so and ICC, as well as the mandate laid down by the Honorable Appeals Court, it appears that the applicant has made out a case to invoke the inherent powers of this court. Facing criminal prosecution is a serious affair which one shall not be pushed into unless there is substantial material. Merely by making general and vague allegations that the applicant was involved in the crime without mentioning even a specific single incident against him by any of the witnesses would not be proper to push him to face the trial. Same in our case. No specific allegation. No one has come forward. There is nothing. Just vague allegations. Then last judgment, it's the same with us. The aggrieved person is working as lecturer in Rajiv Gandhi Institute of Public Health and Center for Disease Control. Now, I'll just come straight to the last law, how it is laid down. Paragraph 6. Paragraph 6. Though Section 18 of the Act provides for the remedy of appeal for challenging the report submitted by the department. The respondent one, without disclosing the report exonerating the petitioner/accused, lodge FIR before the jurisdictional police. The allegations of sexual harassment at workplace constitute the offense under the provisions of Act of 2013. The cognizance of the offense under Act of 2013 can be taken by the learned magistrate only upon complaint in writing by the victim or any authorized person. Hence, registration FIR by the police is one without authority of law. This is what I keep in. I have been consistently submitting in this case. So, my lord, therefore, on this, based on this legal principle and based on the facts of the case and on going through the FIR, it is a fit case to grant interim, at least interim. I am not saying right now that it should be passed, but at least interim should be granted because the petitioner is still in service and at least till the process is over. My humble prayer before this court is at least this should be stayed. The complaint and FIR should be stayed. This is my humble prayer.
Who is accepting it? This is
Lordship, for respondent 1 to 4, Your Lordship. Your Lordship,
Yes.
regarding the interim, I have objection, Your Lordship. The FIR has been registered on 2nd of March, Your Lordship. So the investigation has been set on motion. And if interim is granted, Your Lordship, it will run counter to the mandates of the Supreme Court ruling in Somnath Malik's case, where it says that FIR is not an encyclopedia of all the imputation and that investigation should not be deterred at a threshold. So, Your Lordship, here,
FIR 2nd March 2025.
yes, Your Lordship. 2nd of April, Your Lordship.
2nd April.
Yes, 2025. So your-
17 March.
Was registered on,
17 March.
no,
Just to correct the facts, 17 March. The FIR lodged by the Chairman Women Commission.
I'm saying registered.
17
FIR
was registered
registration.
on- yeah,
Okay,
registration.
FIR registration.
Okay, okay.
2nd April.
Yes, 2nd of April. So, Your Lordship, at this stage, let notice go, even on the interim.
Yes, I'm not granting interim. We'll
Yes.
consider only after the CD is received.
Yes.
Okay, let the court go to the CD, please. Third learner counsel for the petitioner, Shri Ashpizo. This is an application,
Lordship, I have filed my wakalat this morning.
okay, for respondent number 5.
Yes.
Okay,
Yes,
okay.
in person.
In fact, it could have been included in our official position.
No, this is the action of.
In person.
I'm not challenging the
He's
statute.
the chairman of the.
I'm not
No,
challenging.
you are challenging the action of the
Yes.
As a chairman,
SCW. Actually, it should be in official capacity, actually.
That, in that case, my lord can be, maybe allow me to correct the constitution.
Mhm.
No problem,
Yes,
but
yes. It cannot be in personal
no
capacity.
problem.
If the court is of the opinion that no interim shall be granted, then.
No, no,
Let me not
interim,
say
no
anything.
interim, no, you submit your objection also, it's okay. Yes. What did I say? Learned counsel for the petitioner. No, before that, you say Learned PP as Mary appears for the state respondents
One
number
to four.
1 to 4. And Mr. Cynthia Younger has entered appearance on behalf of respondent number 5. So the application under section 528 of the BNSS, read with Article 226 of the Constitution of India, has prayed for quashing the impugned complaint letter
Yes,
number NSCW/SH/D/2025/121 dated 73/2025, and the FIR bearing number SCPS number 1/2025 dated 2/4/2025, registered under section 74/75 under bracket 2/79 BNS 2023. Stop. The case of the petitioner is that the the FIR has been set in motion on the basis of a complaint by the chairperson of the Nagaland State Commission for Women, allegedly in exercise of powers
Section
under
5.
Section 5 and 6 of the Nagaland Women Commission Act 2026. Stop. The petitioner has stated that the present case is one where the complaint dated 17/3/2025 by the Women Commission does not reveal any specific offense against the alleged accused person, and all the allegations are general and vague.
Yes.
Stop. The petitioner also submits that the cognizance of any offense under the POSH Act of 2013 can be taken by the magistrate only upon a complaint in writing by the victim or any authorized person. And therefore, the registration of the FIR by the police is one without authority of law. Stop. At this stage, the petitioner also praised that the impugned complaint letter dated 17/3/2025 and the FIR dated 2/4/2025 may be suspended during the pendency of this petition. Stop. As a comma, stop comma, as the alleged accused is a serving government employee, and therefore praise that the interim relief may be granted at this stage. Stop. Next paragraph. Issue notice returnable within 4 weeks. Stop. No formal notice needs to be issued on the state respondents. Stop. The petitioner shall take steps for notice on respondents number 6 and 7 by registered post with AD within a period of 5 days. The learned PP shall produce the updated case diary on the next date.
I may furnish a copy of the.
Okay, and the petitioner shall furnish a copy of the petition to the council for the respondent number 5. Stop. The respondents are at liberty to file their objections if so advised. Stop. At this stage, this court is not inclined to grant, to stay the complaint, alleged complaint dated 17/3/2025 and the FIR dated 2/4/2025. Stop. The interim prayer shall be considered on the next date.
No, there's a small prayer then.
Yeah.
And I may be allowed to, with the permanent, I may be allowed to increase
Cost
the
title.
body.
Uh.
Was the as item as response number 8. The state women.
In that case, Lordship, an application may be filed
No, no.
for improvement. Because I believe for that there is a standing notification.
You find an IA?
Yes.
Yes.
No,
If you want to change, because
just.
that will be just a formality, but we have to consider the procedure also, no? Mm.
Much obliged.
For motion from the supplementary cost list, item number 22.
I beg your pardon, my lordship. In the mentioned item number 20,
Mm.
may the interim order be continued. Lordship.
Item 20.
Yeah.
Which, for admission or what?
Hearing
Hearing.
item 20.
Oh, hearing item 20. The interim order given earlier shall continue till the next day.
Much obliged.
Yes, motion item.
22.
Who's appearing?
This instant item is filed for condemnation of delay of 33 days in MSC Tribunal demand for case number 77, 2014.
How many days?
33 days, your lordship.
33 days.
Mhm.
Heard learned counsel for the appellant. MS such and such. In IA 51 of 2025. Stop. The application is filed under section 5 of the Limitation Act 1963, praying for continuation of delay of 33 days in filing the connected MSC appeal number 4 of 2025. Stop. Issue notice to the respondents number 1, 2, and 3. Returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondents 1, 2, and 3 by registered post with AD within a period of 5 days. So, lists after 4 weeks.
Much obliged, your lordship.
For motion from the supplementary cost list, item number 23.
May I please, your lordship? Yes. Your lordship, by this instant writ petition, the petitioners are seeking for regularization of their past services in order to receive pension and pensioner benefits.
Mm.
My lord, the petitioners came to be appointed as work charge labor fixed pay under the office of the SDO Mon Nagaland in the office of the executive engineer Mon.
Mm.
And your lordship, despite serving the department for more than 35 years of service,
Mm.
they were made to retire on fixed pay.
Mm.
So your lordship, the petitioners are challenging the office memorandum dated between 2nd of September 2004 and
Mm.
17th of March 2015.
Isn't there a notification recently issued by the state government regarding fixed pay? You are aware that sometime in March, I think, no?
Yes, yes, your lordship.
You're not covered by that.
No, your lordship, though that office memorandum is about those employees who are in
Fixed.
service, but I'm retired, your lordship.
Oh, already retired.
Yes, your lordship, retired, your lordship. For that, your lordship, these two OMs are under challenge since.
But 2019, you retired in 2019.
Yes,
We
Your
are now in 25.
yes, your lordship.
How do you explain the delay? Have you explained the delay? You're coming after, say, 2019, 20, 21, 22, 23, 24, 6 years.
Your lordship.
6 years. What were you doing for these 6 years?
The petitioners are from a very far from village. They are from Mon, which is
Mm.
declared as most backward area.
Hmm.
So they were not aware of this legal, your lordship.
No,
So
but
after-
at least
after
have you made
immediately
any
approach, they are
explanation in
approaching.
your petition regarding the delay? Have you said anything?
Your lordship, for pensionary, there is
When you have been sleeping over your rights for 6 years, we'll just issue notice, but that may have to be considered at the next date, no, on the next date.
lordship.
Heard learned counsel for the petitioner, Ms. Atsila Kips. Stop. It is stated that the petitioner, number 1, It was released from service on 28 to 2019 after serving for 37 years, 4 months and 7 days. And the petitioner number 2 was also released from service on 31/3/2019 after completing 35 years and 24 days. Stop. The petitioners are therefore before this court praying for regularization of the service so as to avail pension benefits. Stop. The petitioners are also challenging the policy and scheme for regularization of work charge employees being office memorandum dated 17/3/2015 and 22/9/2004. You put that first, 22/9/2004 and 17/3/2015. Stop. Learned government advocate M. Locomer accepts notice on behalf of all the respondents, no?
Yes, sir.
On behalf of all the respondents, number 1 to 5. Hence, no formal notice is issued. However, the petitioner shall supply extra copies of the petition to the learned government advocate. Issue
In
notice
the course of the day, Your Lordship.
during the course of the day. Issue notice returnable within 4 weeks.
Your Lordship,
Yes.
I have a prayer here, Your Lordship. On a similar matter, on an earlier writ petitions, the single bench did not interfere on this, which was challenging the same OMs. However, the petitioners had preferred an appeal,
Mhm.
and WA 25 of 2024
Which is pending
is pending. So I pray that this matter may be listed after the
Along
disposal
after the disposal
of
of
this.
that.
Yes, the two WA.
At the outset, the learned government advocate has submitted that there is a writ appeal number
WA 25 of 2024
25 of 2024
WA 26 of 2024.
and WA 26 of 2024,
Yes, sir.
which are pending disposal and where the issue of legality regarding the said OM dated
Yes.
22/4/2004 and 17/3/2015 are under challenge.
Yes, Your Lordship.
Accordingly, it is prayed that this matter may be listed after the disposal of the said writ appeals. Stop.
Your Lordship, I have one more prayer.
Yeah.
The registry may also direct it to make necessary correction in the cost list as Wang Sheng K and another. Since this petition pertains to 2 petitioners, my lord.
Okay, okay.
I have written as Wang
Wang
Sheng K.
Sheng K and another.
Yes, Your Lordship, in the next listed date.
Yes, yes. So on the next date of listing, the registry shall also reflect the post title as Sri Wang Sheng K and another. So, this is the matter after disposal of WA 25 and 26 of 2024.
Much obliged, my lord.
Obliged, Your Lordship. Okay.